Hi, this is Richard Chamberlain, and welcome back to the Protecting Your Family's Future podcast. This is episode number 47 in the podcast, and today we're talking about how to deal with automobiles in a probate estate. We're working through our series on probate issues and how to handle things that come up in probate. Last week, we looked at how to deal with real estate as a specific asset. Today, as I said, we're going to be talking about how to deal with automobiles. There are issues that come up when we have automobiles that are in a probate estate. They come up in lots of different ways, and they have to be dealt with in different ways depending on the circumstances of the estate. But we're going to try to hit on some basic principles in this podcast today. So there are a couple of different ways this comes up, as I said. Number one, the decedent owned an automobile and there was not a lien on it. The decedent owned an automobile and there is a lien on it, or the decedent had a car that they leased. Now, the leased automobile is probably the easiest one to deal with because the decedent didn't own that. They had a contract with a leasing company for the lease of the car. That just needs to be turned back into the leasing company. The contract for the lease gets worked out between the person in charge of the estate and the leasing company. So we're going to focus mostly on a car that is owned by the decedent, either outright or with a lien on it. So when we have an estate really of any kind, one of the things we have to do is, of course, prepare an inventory in the estate. We talked about that several weeks ago, about how to value assets and put that into the estate inventory. When there is an automobile, of course, the automobile has to be valued, appraised. We can sometimes use the Blue Book value that we can get from online, or we will have it appraised by a qualified appraiser for that particular kind of vehicle. When the inventory has been submitted to the court and then finally approved by the court, then the estate fiduciary, the executor or the administrator, is then able to do whatever they're going to do with that automobile. They can either transfer it to a beneficiary or they may sell it. If they're going to sell it, that would often be because there's a lien and the estate receives the sale price from the buyer, uses that money to pay off the loan, and then they can transfer the vehicle to the buyer. Now, a couple of different scenarios come up here. If there is a will, and the will has what's called a power of sale, which is a provision in the will that gives the executor the power to sell assets, then it's not necessary for the estate executor to get an order from the court allowing the executor to sell assets, including an automobile, because that's included in that power of sale. However, if there's not a will, and we don't have an executor, we have an administrator. Or if there's a will, but it does not include a power of sale, then in order to sell the personal property of the estate, including an automobile, the executor has to file an application to sell personal property of the estate. Has to get the authority or the approval of the estate beneficiaries or the heirs. And then the court would approve the sale of that property. Regardless of whether there's a power of sale or not, once we get to the point where the sale can happen for an automobile, there is then, once there's a buyer obtained, the executor or the administrator has to file an application to transfer a titled vehicle. Now, this is not only for automobiles, but also boats or any other titled vehicles. And it's a request to the court to order that particular titled vehicle, automobile or boat or what have you, be transferred to the buyer. or to the person who is the designated beneficiary of that asset. Part of that form says that we are transferring this vehicle either by purchase or by the statutes of descent and distribution or by a specific devise in the will. So once that is approved by the court, then that titled vehicle, that automobile, can be transferred to the buyer, and either the money from that sale deposited into the estate account, the lien paid off if there's a lien, or just the vehicle is transferred to that beneficiary. So a lot of different issues when automobiles are involved in a probate estate. It's best to, of course, handle those on a case-by-case basis to find out what we need to do with this particular automobile, depending on the specific facts and circumstances that arise for each estate and each vehicle in that estate. So it can be a little bit confusing, but I hope this information has been helpful for you. If you have questions about a probate estate that you're involved in, or if you're looking at planning your estate so that maybe your estate will avoid probate, if you're in Ohio or in Michigan, you can reach out to one of our attorneys, schedule a consultation to talk about those types of things for you. As I said, I hope this has been helpful for you today, and we'll see you again next week. Thanks.